Your Excellencies, distinguished guests, colleagues and friends, a very warm welcome to all of you on this cold day in the International City of Peace and Justice. My name is Christophe Paulussen and I'm the acting chair of the Executive Board and academic director of the T.M.C. Asser Institute. I'm thrilled and honored to kick off this afternoon in the wonderful Peace Palace, the worldwide icon of peace through law. Today, we have come together for the 9th Annual T.M.C. Asser Lecture, our flagship event that aims to foster dialogue between leading international legal scholars and practitioners on pressing global issues. The T.M.C. Asser Lecture Series was established in 2015 on the 50th anniversary of the Asser Institute. It honors the Dutch jurist and Nobel Peace Prize recipient Tobias Asser, whose vision of an international society based on trust and respect remains an aspiration worth pursuing. This year's lecture, titled Connection in a Divided World, Rethinking Community in International Law, will be delivered by Professor Fleur Johns, a renowned expert on the intersection of law, technology, and international relations. We are privileged and grateful that she has accepted our invitation to share her wisdom with all of us on this crucial topic. The concept of community has long underpinned international law, serving as the foundation for promoting public interests and fostering solidarity. Recent examples include the community interest being invoked in cases before the International Court of Justice, in the Great Hall of Justice located in the building behind me, with states seeking accountability for alleged violations of international law. However, the unifying concept of community also holds a darker history in international law, often excluding and marginalizing based on race, religion, or other factors. Professor Johns will delve into this complex, fundamental, and timely topic, addressing crucial questions about the evolving nature of community in the context of international law and humanitarianism, and what this means for global relations. We're very pleased that Professor Johns will be speaking on a topic that is so closely related to the Asser Institute's research agenda, which focuses on the notion of the public interest. In our research, we try to understand how the notion of the public interest is constructed through legal arguments and public discourse. So who participates in these discussions on the public interest? Whose voices are heard and whose are excluded? Most importantly, what are the societal consequences of different interpretations of the public interest? Do they promote fairness and justice, or do they exacerbate existing inequalities? We're confident that Professor Johns' extensive expertise and research positions her uniquely to help shed light on these and other issues. Now, in a couple of minutes, I will further introduce Professor Johns and her work to you, but first I would like to give the floor to Rob Schuurmans. Mr. Schuurmans is Deputy Director of International Affairs at the Hague Municipality, which is a co-host of the Asser Annual Lecture. And as Head of Acquisition and Account Management, Mr. Schuurmans is responsible for the further development of the Hague ecosystem of peace and justice. Mr. Schuurmans, thank you so much for your willingness to say a few words of welcome and for your support in making the Asser Lecture a reality. Thank you.
Your Excellencies, distinguished guests, on behalf of the Hague Municipality, I warmly welcome you to the Peace Palace, the heart of our international city of peace and justice, a symbol, but for more than a century now, also the beating heart of the international legal order. This year, it is precisely 125 years ago that the first International Peace Conference took place in The Hague. And although The Hague's historical association with international law predates that conference, that very moment marks for us the birth of The Hague as the legal capital of the world. In the context of today's lecture, this is relevant for two reasons. The first of which is that the Hague Peace Conference of 1899 was driven by a global sense of community in a divided world. The world peace movement was a pivotal factor in its success. While international delegations spent 2 months haggling, caught up in a web of political interests, this international humanitarian community applied pressure for decisive action. And this ultimately led to historical breakthroughs in international law, the most notable being the founding of the Permanent Court of Arbitration, world's first truly international court. Conflicts no longer had to be settled on the battlefield. From that moment on, this could be done using international law in The Hague. Now, a second reason for the relevance of that first Hague Peace Conference for today's lecture is that its success also depended on outstanding individuals, one of whom was the Dutch jurist Tobias Asser. It is given to few to be at the inception of so many important international developments as he was. As the Netherlands delegate to the Hague Peace Conference, it was his imagination that also helped ensure its success. A few years earlier, he had already initiated the Hague Conference on Private Law, and until his death, he was active in efforts to establish the Hague Academy for International Law. As an arbitrator at the Permanent Court of Arbitration, he was also an advocate for international law in the literal sense. He was awarded the Nobel Peace Prize in 1911 in recognition of his efforts, an honor which to this day still fills us with pride in The Hague. In an in memoriam article in the American Journal of International Law in 1913, the journal predicted that his zeal would long outlive him and his name would conjure with the international community. Now, more than 100 years later, it is clear that this was a prophetic statement. The Asser Institute has honored his name for more than 5 decades, with its leading position as a renowned center of expertise in international law. However, what many people do not know is that the Asser Institute is also very closely involved with the local community in The Hague. The Institute plays an important role in bringing together town and gown. It works with our youngsters in schools, students in our universities, and together with the municipality, the Institute thinks of ways in which peace and justice can be made tangible for The Hague's residents. For all this, the municipality is very grateful to the Institute, which is reflected in our support for the annual lecture. A lecture that indeed traditionally brings together The Hague's peace and justice community in search of a deeper understanding of current trends and developments in international law. While the Peace Palace is still the beacon of this vivid community, its influence now reaches much further. Today, in The Hague, more than 20,000 people in over 500 organizations are working together for peace and justice. And although the international legal order has expanded in the past 125 years, unfortunately, so have the level of threats and the complexity of conflicts around the world. In The Hague, we therefore now reflect on the question, what will it take to foster our international city of peace and justice over the next 125 years? Finding an answer to this question starts indeed with the need for a deep understanding of the challenges that lie ahead. We are therefore also looking forward to hearing Professor Fleur Johns' words of wisdom today. Her brilliant work resonates with us for 2 reasons, and we hope her lecture provides us and the entire peace and justice community in The Hague with a point of reference. First, in The Hague, we are aware of the opportunities and risks presented by digitalization and new technologies. Diverse Hague-based organizations, for example, create digital tools or use big data to help coordinate humanitarian efforts worldwide. At the same time, cyber threats rise and the international community is at risk. We therefore protect humanitarian NGOs in The Hague with a comprehensive cybersecurity support program. But do we really understand all the legal and policy implications of digital humanitarianism? Second, we in The Hague also believe in the power of community. It is through communities, after all, that cities have been able to thrive throughout history. From current community building initiatives in our neighborhoods back to the global peace movement of yesteryear, humanity needs community. Now more than ever. But communities can indeed also exclude and divide people. New technologies even increase that risk. And while technological innovations have so far mostly served the market, such as shareholders of tech giants, or the state, such as dictators in repressive regimes, we in The Hague prefer to work with technological innovations that truly serve the people. But how can we understand the dynamic of technology and community in a divided world? We are delighted that Professor Fleur Johns will shine her light on these and other issues in the 2024 annual lecture. We hope that, in the spirit of Tobias Asser, she can use her imagination to inspire us all to reach beyond our own community, so that, together, we can advance the international legal order in the 125 years to come. And in those efforts, you will always find The Hague at your side. Thank you.
Thank you, Mrs. Schuurmans, for your kind words and again for your support. And now, let me introduce to you Professor Johns. Fleur Johns is Professor in the Faculty of Law and Justice at the University of New South Wales in Sydney, Australia. Recently, she was appointed as the new head of school and Dean of Sydney Law School, where she will be starting next year. Professor Johns works in international law, legal theory, law and development, and law and technology. And her latest research has focused on the implications of digital technology for international law and politics, and on the international law of diplomacy. She has published 5 books. The most recent is #Help, Digital Humanitarianism and the Remaking of International Order, which describes the transformation of humanitarian aid by digital technologies and why this matters for law and politics on a global scale. Professor Johns is further a Fellow of the Academy of Social Sciences in Australia, an Australian Research Council Future Fellow, and a visiting professor at the University of Gothenburg in Sweden. She currently serves on the editorial boards of the American Journal of International Law and the journals Technology and Regulation, the Journal of Cross-Disciplinary Research on Computational Law, and Science, Technology and Human Values. She's also an advisory editor for the London Review of International Law, the Australian Feminist Law Journal, and several scholarly book series. For the annual T.M.C. Asser lecture, we always aim to invite speakers who are more than expert international lawyers. Our speakers are public intellectuals who dare to address the questions of our times. And Professor Johns is exactly such a person. Dear guests, I invite you to join Professor Johns in collectively engaging with the concept of community, its past and current challenges, and its potential for fostering a more just and fair world. In these divisive times, this is the fundamental discussion we need to have. So, dear Professor Johns, dear Fleur, thank you so much for being with us here today. You have the floor. Please give a warm welcome to Professor Fleur Johns.
Thank you so much. Thank you. Your Excellencies, distinguished guests, friends and colleagues, ladies and gentlemen, it's a great privilege to deliver the 9th Annual T.M.C. Asser Lecture, and one for which I'm grateful. The 2019 biography of Tobias Asser by Arthur Eifinger reveals him to be an intriguing, brilliant and provocative figure. deeply committed to his students and to nurturing the intellectual life and life of the university and the profession, but also energetically engaged with the citizenry at large and with the most pressing issues of public concern and public debate of his day. I hope that this afternoon I can carry forth something of that spirit, even though my take on the themes that I will broach doubtless differs quite markedly from the take that Tobias Asser would have taken in his day. I was thinking about it the other day. You're quite disconnected from a lot of your friends. This was what my eldest child, now 18 and in his first few months of university, said to me recently. "You mean I don't travel in a pack?" I said. He said, "Yeah, why is that?" I could see why he might wonder. At the time, a dear old friend was in town for several weeks, and we remained close, and he could see that. But she lives in London, I live in Sydney. We see each other once a year, if that. We correspond very sporadically, the odd text and call here and there. For him, both physical proximity and constant communication are everything. For me, connection is more a matter of feeling, something born of past experiences as much as those in the present. I responded to his question with a meandering parental disquisition on all the forms of friendship that I cherish. I got quite carried away. He replied, eyes glazing, and started fiddling with his phone. He disconnected. If one were to caricature the difference between our respective approaches to connection, one might say that my son's sense of connection is more digital in its logic. That is, binary, on or off, in or out, something or nothing. No value is ascribed to any intermediate state. And much as technologies of packet switching allow for concurrent transmission of lots of chunks of data across distributed networks, so my son is concurrently connected via multiple interfaces, talking to me while on Snapchat, with one AirPod in his ear tuned to a shared playlist on Spotify. My approach, on the other hand, is perhaps more analogue in its logic. It is concerned with comparisons and continuums, degrees of likeness and dissimilarity, relative closeness and remoteness across space and time, much as analogue technologies work with the continuously variable properties of physical phenomena. Think of a ruler or a mercury thermometer or the volume dial on an analogue radio. Now, I refer to this as a caricature because both my sons and my friendships are actually tangles of analogue and digital logic. They depend on both. And international legal connections similarly rest on both these logics and on their entanglement. International lawyers are, of course, no strangers to binary logic. Legal versus illegal, citizen versus non-citizen, combatant and non-combatant. These and other binary classifications are important in the field, as you know. And yet we international lawyers tend to trade often in more or less comparisons and in analogies. Think of how, even in the absence of a doctrine of precedent, international lawyers reason from prior cases. Or consider how would-be states must assert their statehood by demonstrating similarity to other existing states concerning territory, population and government. These are analogue connections, framed as continuums and conveying expectations of continuity across time and space. I began with a story drawn from my everyday family life, a kind of story not usually told in this venerable place, to illustrate what is most interesting to me about the spread of digital technology into all areas of global life, including humanitarian work, about which I've written elsewhere. That is the way that it enlivens anew at every scale, from the personal to the global, dilemmas with which international law has long grappled, namely how to live together without living together, how to structure and sustain legal relations at scale without presuming any perfect convergence of values or relying on co-presence in time and space. One arrives at different answers to the questions surrounding this dilemma, depending upon whether one prioritises digital logic or analogue logic. My son finds my analogue version of friendship unconvincing because it spans large distances and entails relatively infrequent communication. It's too detached from the day-to-day. I sometimes find his more digital version troubling because it seems overly transactional, a little thin, one might say insufficiently grounded in history, or too beholden to flux and fad. We can hear versions of this tension between analogue and digital logics playing out in all sorts of international legal debates. We hear this especially when the uneven ubiquity of digital technology is under discussion. A recurring phenomenon whenever effects of digital technology are being debated in the international legal field is profound disagreement about the relative value of relations structured according to digital logic and those structured along analogue lines. Think, for example, of international lawyers' usual worries about post-truth politics, for instance. To some, the problem is that we have strayed too far from analogue ideas about truth, and institutions dedicated to nurturing and defending that truth have been eroded or discredited, say the quality press or multilateral institutions like the UN. These are champions of analogue logic because they tend to position themselves on a more or less scale of human perfectibility, even as they rely on binary coding too, high, low, good, bad. The move or the aspiration for movement is always along a continuum, ideally from ignorance and violence towards greater insight and more peaceable deliberation. Meanwhile, forces marshalling against these institutions often seem to stress the digital more than the analogue. Think of the black-white yes-no of the extremist or the distributed digital networks of social media. To others, the problem of which post-truth politics is symptomatic rests precisely with these analogue-heavy institutions, their exclusiveness and hoarding of power. Some hope that dialling up digital logic might orient them in more egalitarian directions, countering a crude inequality with discrete fact. Think of citizen journalists armed with cell phones collecting evidence in anticipation of some international criminal court investigation. Now, one could talk a lot more about how and where these contradictions surface or unpack the digital analogue tangles within them differently. But my concern this afternoon is not so much with these tensions themselves, so much as what they might enable. And among the international legal dilemmas newly enlivened by these tensions is what one might call the problem of international community. How should international lawyers articulate and defend relations of community on the international plane? Can it be done without insisting on universal values that many scholars have shown to be partisan and many peoples have found assimilatory? Without subscribing to neoliberal fantasies of a level playing field and equal opportunity in the global markets? Without conceding too much power to those with greatest hold over prevailing infrastructures of connection and communication? Without evoking communitarian romanticism and stirring reactionary attachments to blood, soil, and yesteryear? These are perennial questions for international law, but as my briefest of excursions into debates about post-truth politics suggests, they are surfacing afresh wherever technological change is giving digital analogue tensions renewed prominence. This is the dilemma that I want to focus on this afternoon, the problem of international community. And even though I have suggested to you that tensions between digital connection and analogue connection pose this problem anew, I'm going to say relatively little about technology today, unless, of course, we want to discuss it more in the Q&A, although we will come back to digital and analogue logics later. Instead, I'm going to talk mostly about what has been going on recently right here in the International Court of Justice, events with which you are doubtless very familiar. I speak on these as a general international lawyer rather than a specialist in the jurisprudence or procedure of the court, of which there are several in this room. My argument is that the fleshing out of doctrine and practice around erga omnes partes obligations and rights of intervention that has been happening in ICJ applications and is ongoing articulates an intriguing new approach to the problem of international community. Now, for some of you, over the next few minutes, I'm going to be covering some very familiar ground. If that's the case, please bear with me until we come back to the way that I am inviting you to think about that familiar ground afresh. Community, in the version that I am going to draw out of some recent ICJ applications, leverages both digital and analogue logics. And it is at once active and inactive. Let's call it attenuated community, wherein community remains a potent idea, but its menacing properties are expressly acknowledged and countered. I'm drawing an analogy to an attenuated vaccine that is created by taking steps to reduce the virulence of a pathogen while still keeping that element viable. Assertions of attenuated community are active in that they have the effect of prizing open pre-existing legal relations and settings of alleged communal violence and inserting an expanded idea of interest within them, insisting that more people and more governments have an interest in those relations than international law has traditionally allowed. And wherever this is asserted, that enlarged sphere of common interest is not generic. It bears the trace of long, complex histories of relations and solidarities among those concerned in each instance. At the same time, assertions of attenuated community are inactive in that they do not seek to enclose those who endorse this enlarged sphere of common interest in a value clique. Recent claims of community do not presume perfect agreement or a singular viewpoint or absolute equality or co-presence or any other kind of continuity or oneness among those articulating common concern. And the common interest asserted is also not necessarily expected to endure. In these specific senses, attenuated community entails an anti-community assertion of community. Those making assertions of attenuated community cut across scales and other versions of community in which international law trades, and they do so with particular struggles in view. This is important. Attenuated community emerges from a politics of egalitarianism, aimed at piercing through unequal power relations and countering violence associated with those. The common interest being asserted is not transactional or born of deal-making in the market. What attenuated community does share with neoliberal community, nevertheless, is an embrace of contingency. When international community is attenuated, it is not meant to serve for all places and times. It is advanced in and for the context of a particular conflict. It is at once solidaristic and open to ongoing negotiation. To bring this to life, let me say some more about how assertions of attenuated community might be discerned in some recent and pending ICJ proceedings, and how they stand apart from other, more familiar evocations of community in the international legal field. What has been apparent, at least since the ICJ's 2012 judgment in the case known as questions relating to the obligation to prosecute or extradite, which you will recall was a dispute between Belgium and Senegal regarding criminal proceedings under the Convention Against Torture, is the affirmation and gradual widening of states' capacity to sue other states before the ICJ by alleging breach of erga omnes partes obligations. Now, for the non-lawyers in the room, those are obligations that a state party to a multilateral treaty owes to all the other state parties to that treaty, in view of all those parties having an interest in the treaty being upheld. By relying on obligations erga omnes partes, any state that is a party to a treaty may institute legal proceedings protesting non-compliance with that treaty, regardless of whether or not they were directly injured or materially affected by the breach alleged. Now, the doctrine and scholarship relating to these developments goes back much further than 2012, and it is expansive. And it has been well surveyed by many, including Pok Yin Chao, Mariko Kawano, Christian Tams, Yoshifumi Tanaka, Priya Urs, and the former ICJ judge Bruno Simmer, among others. I'm not going to walk you through that literature here. Let me focus instead on some recent events. In 2019, the small West African state of the Gambia, with a population of just over 2.5 million people, about 96% of whom are Muslim, filed an application with the ICJ, with support from the Organisation of Islamic Cooperation. This application concerned actions taken in Myanmar, a Southeast Asian state, some 11,500 kilometres away. Myanmar is about 60 times the size of the Gambia territorially speaking, and has an ethnically diverse population more than 20 times larger. That population is predominantly Buddhist, but Myanmar is also home to a small Muslim minority. And the Gambia and Myanmar, as you know, are two of the most impoverished countries in the world. To the media, the Gambia's former Attorney General and Justice Minister, Abubakar Tambadou, described the case as one informed by his country's endurance of 22 years of brutal dictatorship. But this was not without some irony, however, given that its current president, Adama Barrow, has faced criticism for reneging on a promise to step down from office and cracking down on protesters at home. In the ICJ, the Gambia sought to, quote, establish Myanmar's responsibility for violations of the Genocide Convention through what it has alleged are, quote, its genocidal acts against the Rohingya group, a distinct ethnic, racial and religious group residing primarily in Myanmar's Rakhine state at the far west of its border with Bangladesh. The Gambia did so invoking both erga omnes partes obligations under the Genocide Convention, to which both states are parties, and erga omnes obligations owed to all states under general customary international law. All states, the Gambia is arguing, have a, quote, common interest, a common legal interest in preventing alleged genocidal treatment of the Rohingya. In 2022, the ICJ ruled by 15 votes to 1 that it has jurisdiction to hear the case, rejecting Myanmar's claims that the Gambia had no legally recognisable stake in the Rohingya's mistreatment. In doing so, the court acknowledged the Gambia's treaty-based interests, but not its claim that all states are owed erga omnes obligations under general customary law as well. The court was silent on the latter. In late 2023, the Gambia's assertion of this common interest was echoed by 7 states that exercised their right to intervene in the case, and did so in terms supportive of the Gambia, thereby agreeing to be bound by its outcome. They were Canada, Denmark, France, Germany, the Netherlands, and the United Kingdom acting together, and the Maldives acting independently. Historically, as many of you know well, this kind of intervention by other states in a dispute between 2 states has been quite rare, but it has been happening a lot more lately. The Gambia's was the first case ever brought before the ICJ under the Genocide Convention by a state not alleging that any of its nationals have been victims of genocide. For the non-lawyers in the room, this is significant because of the way that it breaks with the idea that the ICJ is and should be primarily concerned with resolving bilateral disputes between offender states and victim states, where the latter can show that they have been directly harmed by the offender's illegality. Now, the ICJ has always had the capacity to give legal advice beyond the scope of such disputes by issuing advisory opinions, and as you've heard, its rules allow for other states to intervene in bilateral disputes. But its dispute resolution work has not historically entailed much arbitration of common interests among otherwise disparate states. Indeed, the ICJ has been somewhat hostile to common interest claims in the past. Think of the court's ruling against Belgium in the Barcelona traction case, for instance. In 2023, two other states, Canada and the Netherlands, followed the Gambia's lead. They instituted proceedings against Syria for failure to comply with another multilateral treaty, the Torture Convention, in relation to Syria's alleged mistreatment of activists and dissidents since 2011. Like the Gambia, they did so without alleging that any of their nationals had been victims of torture. Again, they invoked common interest in ensuring compliance with the Torture Convention, and again the ICJ ruled that this was a sufficient basis for moving forward with the proceedings. The politics of this gesture of allegiance, however, were quite different to those underpinning the Gambia's case. Both Canada and the Netherlands were active in the war against Islamic State in the 2010s, as you will recall, in which context both states participated in the bombing of Syrian territory. And those operations were justified to domestic constituencies, in part by the need to support the Syrian opposition. So Canada and the Netherlands have been directly implicated in surrounding violence in a way that the Gambia has never been in Myanmar, making their positioning themselves on the side of the Syrian people opposing President Bashar al-Assad rather awkward. And whereas the Gambia's concerns about violence towards Rohingya Muslims were channeled through the Organisation of Islamic Cooperation, the concerns of Canada and the Netherlands were expressed in more generic human rights terms. Even so, the case demonstrates how the Gambia's erga omnes partes claim has had broader resonance and influence. In late 2023, another African state, this time South Africa, instituted ICJ proceedings under the Genocide Convention, invoking a common interest in ensuring genocide is prevented and punished. As is well known, these proceedings concern acts and statements of the State of Israel against the Palestinian people in the wake of the attacks on Israel of 7th of October 2023. Like the Gambia, South Africa has invoked both treaty-based erga omnes partes obligations owed to it by Israel and obligations erga omnes under customary international law. It has done so against the background of a long-standing political relationship between South Africa and Palestine. The African National Congress and the Palestine Liberation Organization maintained close relations throughout the mid to late 20th century, and Palestine has long garnered support from the Congress of South African Trade Unions. Unlike the Gambia, South Africa faced no opposition to its standing in this case. Israel has, as you know, contested the application on other grounds before the court, and the case remains pending. But Israel has never contended that South Africa lacks a legally recognisable interest in Israel's treatment of the Palestinian people. In a January 2024 ruling on the provisional measures sought by South Africa, the ICJ signalled its prima facie acceptance of South Africa's treaty-based interest in this case. That is, its standing to invoke erga omnes partes obligations. Again, the court did not address whether South Africa could invoke similar customary obligations in the absence of a treaty in common. Nicaragua has applied to the court for permission to intervene in that case, invoking, quote, the same erga omnes legal rights and obligations, end quote, as those on which South Africa's case is based. And once again, there is a fraught history of political allegiances and antagonisms underpinning that assertion of legal interest. In Nicaragua's case, that is a history of Sandinista Palestinian political allegiance dating back decades and long-standing antagonism towards Israel traceable to that nation's support for the Somoza government and the Contras, and allegations of anti-Semitism against the FSLN, the Sandinistas. Colombia too has filed a declaration of intervention in this case as a party to the Genocide Convention, explaining that it is, quote, endeavouring to act as a responsible member of the international community and trying to advance, quote, joint and coordinated action of the international community. Yet again, the background to this assertion of community is quite distinct. Unlike Nicaragua, Colombia's relations have historically been far stronger with Israel than with Palestine, although Colombia officially recognised the state of Palestine in 2018 and recalled its ambassador from Tel Aviv in late 2023. And more recently, as you know, Nicaragua has instituted related ICJ proceedings against Germany. So, what does all this have to do with ideas of community in international law? It must be said that the ICJ's willingness to hear at least some of these kinds of common interest claims does not necessarily entail or foreshadow any fleshing out of the international legal notion of community by the court. At the end of an expansive survey of the concept of international community in international legal scholarship and ICJ jurisprudence as it stood in 2013, Glyder Hernandez observed that, quote, the court has not arrogated for itself any central role in sketching the contours of the notion of international community. And he continued, there is nothing to suggest that the court is anything but most reticent to engage in any such project. I think that Hernandez is right about that. The interim rulings issued so far in these cases exhibit caution on the erga omnes front, and references to the international community have been notably scarce in most of the relevant pleadings and rulings so far. With the exception of Nicaragua's application, which referenced international community quite extensively, the language of common interest has mostly taken centre stage rather than that of community. Nonetheless, what is striking in this recent lineup of cases are the strategic alliances that they forge and express, and the way that these work against modes of community in which international lawyers have typically traded. That is, against universalism, against market contractualism, against nostalgic communitarianism, against centralised convergence. As a result, these recent cases bear very significantly on how international lawyers have mobilised and might yet mobilise notions of international community and common interest in their work. So how exactly have international lawyers tended to think and talk about community? Well, it's often cast as something lacking. The notion of international community does a great deal of work in the international legal field in a negative register, as something lesser than promised, or in some writings, entirely phantasmic. Harlan Cohen has written, for instance, that the term community is vague and overused. Monica Hakimi has argued that erga omnes obligations and their counterpart jus cogens or peremptory norms, quote, do not meaningfully foster the kind of community that they depict on their face. Dino Kritsiotis has summarised international community's shortcomings pithily as follows. Our international community is deep enough to have conceived of the idea of jus cogens, but not deep enough to know what to do with it. To Andreas Paulus, international community is a diminutive functional term, a shortcut for the endeavour to tackle common problems. Christian Tams has observed that it is often a marker of failure, writing, many a catastrophe from Aleppo to climate change is portrayed as a failure of the international community. Another way that international lawyers have written about community is to show how it has sometimes been assimilationist or racist. Twale scholarship has been important in this regard. That's an acronym for Third World Approaches to International Law, a body of scholarship, some decades old. The argument runs roughly as follows. Whenever international lawyers evoke a unity, as in the international community, this demands that divergent forces be identified and externalised. And those actors cast as divergent have often historically been racialised. Consider racist accounts of a community of nations comprised of the civilised, for instance. Among the most famous are those propagated by the 19th century Scottish international lawyer James Lorimer, one of the founders of the Institut de Droit International, together with Tobias Asser, who I imagine would have been deeply uncomfortable with Lorimer's anti-Semitic and racist views. Arthur Eifinger's biography of Asser makes only one brief passing reference to Lorimer, suggesting that while they worked together, they were far from kindred spirits. International law, Lorimer wrote, must admit, quote, inferior races into its political community on the basis of, quote, perpetual pupillarity and guardianship, so long as the preponderance of proximate power remains with the superior race, end quote. In these contemptible terms, Lorimer evoked racist nostalgia for community lost, for supposedly simpler times when the international legal order was more religiously and racially homogenous in his view, and powerful states were less vulnerable to challenge. A more contemporary version of this stratified unity entails prioritising the views and experiences of developed nations over those imagined to be at an earlier developmental stage along a single evolutionary spectrum. Whether expressed in racial terms or developmentally, the unity of international community often depends on the scapegoating, subordination and expulsion of forces and peoples identified with disunity or deficiency. Not all commentators in the international legal field identify the unity of community with racist assimilation and nostalgia, of course. Some would identify international community with a planetary consciousness. In a series of ICJ cases, including the fisheries jurisdiction case between Spain and Canada of 1998, the pulp mills case between Argentina and Uruguay of 2010, and the whaling case between Australia and Japan of 2014, judges of the court have drawn strong links between environmental concern and consciousness and a sense of international legal community or community of interest among states. And more broadly, international legal scholars have often used the term international community in the same sentence as one planet, suggesting that humans' co-location in the universe implies our unavoidable normative convergence. The one planet, one law idea, too, has a potentially negative dimension, however. It tends to flatten community into a concern with spatial distribution and biology, stripping ecology of its hybridizing relational implications. It also downplays regional affiliations and countervailing internationalist projects, past and present. Community in the one planet, one law version overstates the extent to which people do in fact inhabit the same space and time globally. This disregards all that historians and anthropologists have shown us about how people inhabit multiple misaligned space-times. The sense of tomorrow with which I am most familiar bears little to no resemblance to the tomorrow of people on death row, for instance, or for that matter, the tomorrow of those who inhabit the soon-to-be inundated islands of Kiribati. Even those who champion community in the international legal field tend to lean into a sense of its deficiency by casting international community as something aspirational or nascent, always yet to appear. In 1998, George Abisab cast international community as an evolutionary stage in the international legal order that would result from the progressive thickening of the law of cooperation. At the same time, he worried that the end of the Cold War had unleashed forces moving in an opposite direction, fostering indifference towards the protection of common interests. 20 years later, Eyal Ben-Venisti and now Judge Nolte still insisted that it was too early to tell whether or not we are on the road to more inclusive, community-oriented global institutions on the international legal plane. What we're seeing in these recent ICJ cases, I think, is a newly generative version of this negativity, although perhaps not entirely new. We could have a conversation about precedents and parallels if we have time. These cases make something fresh out of what community is not. By explicitly countering community action in modes that the applicants allege are violent and oppressive. The common interests being articulated in these cases are worlds away from nostalgic evocations of homogenous community lost or aspirational projections of community to come. And they are anything but purist. Rather, they are deeply fraught, indeed explicitly so. The move that these ICJ applications make is towards community in a near-present, defiant mode. The appeals made to common interest in each case evoke a progressive community assembled for the time being to counter specific forms of community violence that are alleged in each instance. This is the targeted, attenuated community of which I spoke earlier. In each of the ICJ cases that I mentioned, the implied community of common interest has been solidaristically asserted against other community-based claims. These are gestures of allyship, not communion. For example, the Gambia drew attention to Myanmar's, quote, racist and exclusionary vision of national community, end quote, in which the Rohingya are afforded no rightful place. Canada and the Netherlands noted that Syria has defended its conduct as necessary to ensure the security of the community against terrorists. South Africa's application referenced Israeli national laws claiming a united Jerusalem and noted Israel's support for settler communities in the West Bank. In each case, the applicants have cast these communal claims as destructive of community in other modes. It is for this reason that the applicants evoked the international community against them. This is what I mean by an anti-community assertion of community. This attenuated version of community is distinct from an instrumental use of community. The applicant states are clearly advancing their own interests in these claims in a range of ways, but they aren't just trying to cloak self-interest in the guise of community interest. The difference hinges on the complex and specific political histories of struggle from which these claims of common interest are derived. As is acknowledged by the applicants in each of the cases that I mentioned, the common interest they assert does not and cannot serve the purposes of any one state or any administration alone. It is too unwieldy and too sharp-edged to be instrumentally reliable. In the Gambia's application, for instance, the common interest asserted was forged in part among the 57 states of the Organisation of Islamic Cooperation, states with quite different interpretations of Islamic law and religious doctrine. The Gambia made, quote, no secret of this in its written submissions to the court. The application of Canada and the Netherlands likewise recalled their combined efforts to negotiate with Syria, efforts materialised in several multilateral resolutions. As such, their common interest was advanced through the fraught politics of international institutions, with these states' fragile military alliance against the Islamic State forming a somewhat troublesome second layer to that coalition. South Africa's assertion of common interest similarly depends as much on Black South Africans and Palestinians' partially overlapping histories of struggle as it does on President Cyril Ramaphosa's efforts to recalibrate a foreign policy of non-alignment. In none of these instances can common interest be relied upon to do a single state's or a single ruler's bidding. This attenuated community is also quite distinct from an idea of ethical and political community created through dialogue or liberal proceduralism. This is not a global governance project born of ethical balance striking along the lines that Monica Hakimi has so eloquently sketched. It is also not an outcome of the intensification of communication or economic activity. Marshall McLuhan's global village is nowhere in sight. The claims of attenuated community that the Gambia, Canada and the Netherlands, South Africa and Nicaragua have articulated in different ways are premised instead on their claiming to hold something substantive in common with other states and communities for the time being. What is held in common are intensely contested commitments to anti-racism and the value of people living in conditions of political, cultural and religious pluralism. This is part of what is made common through the appeal to common interest in these recent CJ cases. My argument is that we should read these claims to commonality through the specifics of particular disputes, rather than in a register of universalism. What the appeal to common interest does in each of these cases is prevent the violence alleged from being enclosed in the cell of a bilateral dispute. But it also obstructs the elevation of these disputes to any generic universal realm. Instead, these claims restate and wedge open that specific tangle of interlaced struggles that has informed and surrounded the violence in each case, so that others may enter and articulate what is at stake for them in those struggles. Now, we know from the work of criminologist Nils Christie that it is possible to think of conflicts as property that may be stolen, given away, hoarded, or shared. We can also think of a conflict as a resource for figuring out how to live with others. And we know that holding resources in common always demands an adherence to certain rules. So one might say that the rules around erga omnes partes obligations and intervention in ICJ proceedings are having a commoning effect, in that they counter the enclosure of a conflict and its exploitation and domination by a few. In making an erga omnes partes claim, the Gambia does not purport to make the Rohingya's grievances towards Myanmar its joint and equal property. Instead, the Gambia is finding an adjacent and intersecting place in the specifics of this conflict through appeal to international legal technique. What the Gambia's claim does do is insert another set of rule-based relationships into relations between the Rohingya and Myanmar. The Gambia's claim cross-hatches the violence between them with another partially overlapping set of legal struggles, demanding that Myanmar engage with both at the same time. This advances an attenuated notion of international community because the Gambia opposes any reading of its claim as a sign of perfectly integrated unity on the international plane. In its submissions, the Gambia said that it is, quote, proud to enjoy the diplomatic and political support of member states of the OIC and a number of non-Islamic nations, but insisted that it was, quote, the Gambia alone that initiated the ICJ proceedings. And over the course of its pleading, even the apparent unity of the Gambia alone was broken down as it was spoken through the voices of several different agents. Likewise, Nicaragua's application to intervene in South Africa's case insisted that, quote, South Africa is not acting as sole representative of the international community in its case against Israel. The attenuated community evoked by these assertions of common interest is also specific in time. Part of what is being transected and wedged open by these claims of common interest is the sense of a precise historical moment. These claims exhibit analogue logic in the sense that they posit a continuum of legal relations with only some having an erga omnes quality, yet they also leverage digital logic because they are explicitly discontinuous with other dimensions of legal relation. This is not the kind of common interest professed by the Asian and African states that participated in the 1955 Bandung Conference, as they expressed, quote, discontent with the international Western community, in Ahed Samoa's words. These recent ICJ cases are also not indicative of 1990s optimism about imminent prospects for international community's lasting realisation. There is no end in history end of history in sight in these claims. No, it is precisely because assertions of international community seem so hard to make and sustain at the current time that we are seeing them take this targeted, attenuated form, one highly attuned to the perils that surround any avowal of community on the international plane. This claim, that assertions of international commonality are especially perilous at this time, takes me back to that conversation I had with my son, with which I began. One possibility, one hunch that I have, drawing upon work I've been doing for the last decade or so, is that recent assertions of attenuated community before the ICJ are somehow expressive of the fraught entanglement of digital and analogue logics by which relations at every scale are now being travelled. What the applicants in each of the ICJ cases that I have discussed seem to be leveraging is a sense that legal and political relationships are undergoing profound transformation globally. And the mediation of those relationships by unresolved combinations of digital and analogue technology, about which I've written and spoken elsewhere at length, could have something to do with their seeming newly negotiable before the ICJ. Any one of these disputes before the ICJ could, on closer inspection, be shown to depend in part on tension between digital and analogue logics. For instance, Myanmar's 1982 citizenship law exhibits digital logic in its refusal of any interim or transitional state between membership of the so-called national races and membership of associated or naturalised categories. Only the former are afforded full citizenship, while those in the latter category, including the Rohingya, are effectively treated as aliens. In Myanmar, people are by law either one or the other, and their life chances are altered accordingly. At the same time, the government in Myanmar justifies its actions by reference to analogue legal and policy commitments, aimed at, quote, inclusive and continuous development in pursuit of balance across all states and regions. The widely documented involvement of Facebook's systems in promoting hatred against the Rohingya reveals another way in which digital analogue conflicts are or may be at the heart of this ongoing violence. Whatever the forces informing them, recent moves at the ICJ in and around the negative space of international community announce an intriguing new chapter in collective efforts to tackle the problem of international community. And this chapter is one to which I think it is worthwhile attending very closely, with a sense of excitement even about the collective configurations and experimental allegiances that they could inspire. That is the case even as the circumstances in which these claims have been made are utterly and unquestionably devastating. I will certainly be watching closely, reflecting on what can and cannot be made possible in the register of common interest in these darkest of times. As for the kids, my own kids where I began, and the young people bearing the brunt of the violent conflicts at the heart of each of these cases, they will doubtless have their own distinct multi-platform takes. And I'll be listening out very closely for what I can learn from them too, even if that attention is not always reciprocated. Thank you for listening.
Thank you very much for that fascinating lecture and for introducing us to this, in your own words, intriguing new chapter in collective efforts to tackle the problem of international community. Now, let us continue with the Q&A. And our lead here will be my colleague, Dr. Bérénice Boutin. She is senior researcher in international law at the Asser Institute. Moreover, she is coordinator of the research strand on disruptive technologies in peace and security, as well as project leader of the NWO-funded Dilemma project on designing international law and ethics into military artificial intelligence. Berenice co-organizes the Spring Academy on Artificial Intelligence and International Law, a unique training program of the Asser Institute taking place this very week. Berenice's research explores the mutual impacts between new technologies such as artificial intelligence and international law, and this includes the role of international law in the governance and regulation of technologies, and the impact of new technologies on core notions and concepts of international law. Berenice, you have the floor.
Thank you so much, Christophe, and thank you so much, Fleur, for this fascinating talk. It's really interesting how you sketch different types of community dynamics and trace their constructions through the cases brought before the ICJ. And of course, it particularly resonates as we are on the grounds of the Peace Palace. Your analysis really invites us, the room, also as the title of your lecture, to rethink how we understand community in international law, how we mobilize it, and what underlying dynamics we may need to look at a little bit more closely. So thank you again, and we will now open the floor for questions. Before asking a question, we ask you to please introduce yourself, state your name and your affiliation. And we do have quite a rather packed room, so please keep your interventions short and to the point. We have colleagues at the back of the room with microphones, so you will be given a microphone to talk. And we will be taking a few questions at a time, right? Thank you very much. So, who would like to have an intervention? All right, we will start with the gentleman here, next, and then here for the first round.
Thank you. Jeroen Zandberg from the Global Diplomatic Council. I'm working with the Frisians in Germany. They are a recognized minority with their own language. Their issue is it's a small language and it used to, in public administration, it now is not used. Also, the websites are completely German now. It used to be, well, until February actually, it was both bilingual, but they made new websites, so it's now, the websites are better, you have more services, but you cannot use the Frisian language because the Frisian language is not, it does not have a large language model like Google or Microsoft offers. So how can, international law, how can that, what are the avenues to support that?
Thank you.
Thank you.
And there was someone right next. Yeah, thank you, Alexandra.
Yes. Thank you. My name is Shagibat. I'm a recent graduate of the Master's at Leiden University in International Organization. My question has more to do with protests and solidarity movements and the role it plays in this whole international justice and international community. So my thoughts are kind of looking from a historical perspective and then looking at today. How do you think the solidarity movements and protests of the boycotting of apartheid South Africa compares to the global protests we're seeing today calling for a ceasefire in Gaza in two different technological times, and kind of how does the role of protest movements play a role in this system of international community and the demand for international justice? Thank you.
Thank you very much. My name is Khalid Ahmed Chaudhry from International Human Rights Commission. Professor, if I confront with you and I say there isn't any international community, there weren't any collective efforts since Israel started slaughtering of Palestinians, genocide, and there wasn't international community, including UN, when India revoked Article 370, the disputed status of occupied Kashmir, there wasn't any single voice about that. So I heard, and we all heard, the gentleman from the local government. He said, we are extremely happy that we have 20,000 people, individually, collectively working for peace and justice. But is this the peace and justice that Israel is slaughtering, destroying Gaza, eliminating completely from the surface of earth? And we are talking about international community and collectiveness. Thank you very much.
Thank you. Should we do this first round and then go back to the room?
Thanks for these questions. Important and tough questions. Let me take them in order. So this question of the fate of small languages, it's such an important and salient question, and I thank you for raising it. I guess I'd say two things in response. One are that what's interesting is that the technology is allowing different forms of organising around this issue. So I'm familiar with some in New Zealand, for instance, efforts to really develop tools in the Māori language, for instance, and archives and data sets in Māori language. So there is organising around this and possibilities for developing more differentiated, more distributed communities around small languages. But one can't argue with the overwhelming force of certain aggregations of data and the force of things like large language models and the predominance of English in those. So this is one among many forms of inequality being re-articulated in contemporary society that are continuous in some ways with earlier debates around language. I mean, obviously these kinds of inequality around language has been the subject of long-standing debate for many hundreds of years, and Jackie Mowbray is one colleague who has an excellent book on this, Linguistic Justice. So there is a lot of work on it, but it is fascinating to see this reinstantiation of these inequalities in new forms as certain forms of language data become so significant. I mean, it's an area for collective work, is all I can say. The second question around, related questions here around, but great questions around the role of protest and solidarity movements. Let me take that one first. I mean, your question was about parallels between South Africa and Gaza. And that's really, I think, for another day, another conversation, and someone with different forms of expertise. There are obviously, as I highlighted, in formulating, in South Africa, pursuing this case, it's quite clear that those long-standing relationships and some collaborations, not smooth, complex collaborations, underpin this. So they're key to the formulation of this legal strategy and this legal technique. So there's a relationship. But in terms of broader solidarity and protest movements, particularly at universities, which is where I work, I must say I think peaceful protest is a sign of great health in a university. I am absolutely mindful of the concern around rising anti-Semitism, but I am guided in that area by the Jerusalem Declaration on Anti-Semitism, which articulates very clearly what anti-Semitism is and condemns it, as I do, but also makes clear that solidarity with Palestinian calls for justice and informed evidence-based criticism of Israeli government policy and military policy and practice, as with any other government, is not anti-Semitism. And so that is my guide in understanding. But I do recognise many colleagues' concern about rising anti-Semitism in connection with these protests and dimensions of violence. And they're taking many different forms on many different campuses. I, like you, read about them in the media. So I wouldn't purport to say what should or shouldn't be done beyond saying that I'm not generally a fan of police on campuses. the third gentleman, I sense your frustration, and of course it's shared by many people. And that was what I was alluding to. That frustration about the failure of international community to deliver its promise is kind of a constant theme in writing and practice around international community, particularly in its universalising forms, of which human rights is one register. It never seems to really do what it's deliver. So we can respond in many, many ways through various forms of solidarity, community action. What I'm trying to point to is interesting new creative thinking underway through legal technique around possibilities for articulating connection, commonality, common interest that are mindful of the history surrounding thinking and practice of international community. So I see some grounds for optimism, but I recognise that one can't be Pollyanna-ish about these things. And the suffering of the communities that I was talking about in connection with all of these cases is very profound and utterly devastating, as I said. So I sense your frustration, but I guess my response is to try to draw some sense of possibility, some hope around these new forms of connection that are being articulated and the possibilities that they demonstrate for innovative thinking within the register of legal doctrine and legal technique. It has its limitations, but it is not nothing, especially given the way in which these cases are connecting to one another and building a new formulation of legal relationships around well-documented situations of suffering.
Well, take some more questions. I had seen one here to start with. Oh, that's a lot of hands. All right, so I'll go progressively. The gentleman there and the gentleman over there.
Thank you very much for your very thought-provoking presentation. My name is Letizia Logiacco and I'm from Leiden University. I think towards the end of your presentation you seem to place some role into motives. Why are states raising the point of community interest to sue other states? So I seem to understand that in the commoning effect, the motive, so the reason why a state brings the issue in front of the court, has a role to play into the construction of this concept of attenuated version of community. And I think, especially assuming the perspective of a law that takes meaning in the way it is argued, not just in a courtroom, but also in the society at large, I'm thinking, what is the role of other states and of the community at large in forging this community or commonality? And on the other hand, I wonder why you discarded a relative expressing the idea of universality, that also one of the most critical voices of universality, like Martti Koskiniemi, seems to have admitted in some of his writings. So is there a particular reason why you discard the idea of universality, especially because of your, at the start of your talk, you placed some importance in the drive for commonality, in the movement towards an aspiration? Thank you.
Yeah.
Thank you. I'm Rick from Urios Utrecht, and I was just wondering that nowadays we can see a lot of division happening and a lot of polarization, both in national and in international society and communities. And I was just wondering how you think this will play a role in the rethinking of community and international law, and whether this can maybe be, the rethinking of community can maybe be used as a way of going against this polarization that we can see occurring more and more nowadays. Thank you.
And behind you, Alex.
All right. Abgar Hartsunyan. I'm a a student at Law and Society course at Vrije Universiteit Amsterdam. So my question is in light of Nagorno-Karabakh conflict. So hopefully you're aware that there was a contentious litigation, well, in the court nearby, and there were decisions made in that contentious case where the decisions weren't upheld by Azerbaijani side. So just in light of this, how do you think these failures, and you've actually referred to it, in international law to enforce and ensure those jus cogens norms, affect the local societies, and how you think even rethinking these ideas don't really help, because local societies now don't really trust this kind of idea of community or unity. Yeah, fair. Cheers. Thank you very much.
Thank you.
So again, great and important questions. Why discard universality? So it's a great question. I suppose two main reasons. One is that it has been so dominant as a register for thinking community that generally when talking about community, when talking about common interest, the move that international lawyers make, not consistently, is towards a universalising register, the upscaling of an interest. And I take seriously the decades of work that has shown the extent to which universalism has travelled with, as I was saying, racism, assimilationism. And so I think one can't pursue a universalism without close attention to that, as I'm sure you may or may not agree, but I think many international lawyers would agree. So I guess what I'm trying to do here is to show that a possibility for thinking the common that doesn't require universalism, but retains some sense of what international lawyers often pursue when they are adopting a universalist register. So a non-universalist mode of drawing in peoples and governments into a negotiation, into relationship, and without requiring that universalising register because of its dark history. So it's I suppose what I'm suggesting is an alternative to trying to articulate within existing practice an alternative to universal thinking of community. I'm not thereby saying that everyone who pursues action or goals in a universalised register is sort of a fool or a racist. That's not the aim. So it's not sort of everyone needs to be doing this. We should be doing this type of claim. Attenuated community is it. So I'm not trying to kind of universalise that idea, but it's just expanding the repertoire, showing the existing repertoire of international law and the room for manoeuvre within it to be richer and more open to possibility than we might otherwise appear. The question around division and polarisation, again, a great question, and community as a way of arguing against it. This is sort of continuous with my response to the prior question. Now, there you are. Sorry, I lost you for a moment. What I see the relationship slightly differently in that the commoning practice is within division and polarisation. So it's not as though because the difficulty to which we, in many dimensions of resolving division and polarisation, we should of course pursue that because often there are questions of inequality, asymmetry of power, within that. So I'm not saying that you shouldn't continue to pursue resolutions of other sorts, but what I want to suggest is that without actually resolving division, it's still these states, led by African states, are articulating the possibility of common thinking, common affiliation and legal relation without waiting for that resolution. So it is not so much countering, but within. The failures, yes, this question, again, I mean, I absolutely appreciate what you're saying, that the promise of international community is perennially a story of failure, of promises undelivered, unrealised. And so people do continue to flock to international law as a register of hope and possibility, and sometimes that doesn't work out. And yet, I guess I sort of I feel as though I'm repeating myself a little bit here, but I don't fantasise that these shifts in legal technique are going to be meaningful or significant for communities all around the world experiencing injustice and pursuing justice-based claims. But what I am intrigued by, have a sense of optimism about, is that the expansion of erga omnes partes claims and associated intervention does suggest a configuration of communities, the possibility of articulating a legal relationship between otherwise disparate communities that might offer some solace. I don't know if you go to Cox's Bazar and speak to the Rohingya people, in refugee camps there, I doubt that they would necessarily be that aware of this, but maybe at some level there's a possibility of connecting up questions of legal relationship with broader questions of community relation and affiliation.
Thank you. We're going to take one more round of questions, but I am afraid it will be the last because we are slightly behind schedule. So let's go one person here, a person there, and a person there, and that will be the last round. Thank you.
Hi, good afternoon. My name is Veronica. I'm representing ASA Institute and also having background in international relations, history and anthropology. Kind of struck me a few things here. Even in your topic that's on the screen here, you say community in international law, whereas it implies there is national, and that's how law or legal disputes or whatever are being handled. It's between the states. What about non-state actors? Because community is basically, it's a layered term. If we, step aside from any of the theories, it's still layered and is like identity, right? You can be both or have three of those, etc., etc. So basically my question is how the non-state actors and that multi-layeredness of community play a role, and what are the advances there? Thank you.
Good afternoon. Thank you so much for your presentation. My name is Mojan. I'm a Canadian lawyer, and I'm currently studying European and international human rights law at Leiden. My question is, you spoke about the ICJ's reticence to accept community as a notion. And my question is, why do you think that is, or do you have an opinion on that? Does it have to do with the specific historic moment that you referred to that we are currently in, or is it something else?
And the final question, Alexandra? No, it will be over there. Sorry.
My name is Koray. I'm a student in political science student in Leiden University. I was thinking in community and international law, how we can sort of define community in existence of a global hegemonic system. And I was thinking, like, can we sort of conceptualize, I'm sorry, I don't know the legal language that much, but like the erga omnes, claims as a counter-hegemonic movement, sort of contesting the global international law order and the global order in general. Yeah.
Thank you very much.
Do you take those?
Yeah.
Thank you for these questions. What about non-state actors? A great point. When I was briefly sketching or alluding to the surrounding struggles and relationships that in which each of these applications is situated, what I was trying to suggest is that every one of these claims, the international legal technique, can only be understood by reference to long and complex histories between sub-state and cross-state diasporic communities, various forms of non-state and cross-state connections. So I don't see these as divorced from or denying sub-state, cross-state, multi-state affiliation. I think you can only really understand what each of these applicant states or intervening states is doing by closely attending to those relationships and their ongoing negotiation, you know. So absolutely it's a key point, and I would like this way of thinking community to be open to that. I think international lawyers need to engage, as they frequently do, with the specifics of where these claims come from and how they might be being thought by the various actors involved. The ICJ's reticence, I think, I mean, the ICJ has not been reticent insofar as they have been willing to, at the jurisdictional phase and at prima facie phase, to endorse, accept this widening since 2012 and in various ways earlier. So there's an element of non-reticence, but caution, and I guess I think the ICJ, who knows what I have no expertise on this, but I imagine that they don't think it's their role to be sketching out. So I think what is interesting is that this is not coming from the ICJ, this is coming from the applicants, and the ICJ is responding to this. So I think they are seeing the articulation of new forms of commonality, common interest, legal relation, properly being articulated by states and, as I've said, surrounding and intersecting sub-state, multi-state communities, regional and otherwise. So I think I actually kind of find it unsurprising, but also sort of appropriate that it's not the role of the ICJ to be saying, okay, here's a map of the new international community, fit yourselves in, because that's never been the way in which that organisation works, as you know. So when I talked about reticence and caution from the court, it's not that I'm saying that this continued pushing at this door, because each of these states continues to push particularly on the erga omnes side, rather than, I think that will continue to have effect, and I would imagine that we'll see additional cases in this register. And that will, I think, bear upon the court's jurisprudence, but they won't lead it necessarily. This attenuated community as a counter-hegemonic move, absolutely it can be understood in those terms. And I think of many of the stakeholders in each of these cases would aspire to have this doctrinal technique do that work. What I was also, though, alluding to is, and when I said that these are not purist claims, there's complex kind of power relations and, that could be diagnosed as forms of hegemony in these claims as well. So it's not as though it's the kind of, there's not a sort of clear, which sort of relates to the way in which the binary breaks down and becomes entangled with the analogue. So each of these, when I was sort of alluding to the fact that, Canada's and Netherlands' case in relation to Syria is no doubt, incredibly well-meaning and well-intentioned, but still in complex relationship to military policy. And each of the cases, as I was suggesting, has these kind of, slight complexities, and I don't think that's a sign of their failure or I actually think it's valuable to appreciate that and to recognise and explore the room for collective action while recognising those difficulties and kind of impurities, I suppose.
Thank you so much, Fleur, for engaging with us. Thank you to all for your questions. We apologise we didn't have the time to discuss longer, and I would like to invite Christophe back on the stage for closing today's annual lecture.
Yes, thank you very much, Berenice, and thank you, Fleur, for your willingness to engage with our audience. It's time to conclude. I think we have had a wonderful afternoon that has given us a lot of food for thought, Fortunately, we also have some actual food and drinks for you to continue the discussion in a more informal manner. However, before we go to the reception, I would like to thank a number of people and organizations. First of all, many thanks to our host, the Peace Palace, to the municipality of The Hague, today represented by Rob Schuurmans, to today's technical crew, and of course to Berenice for her excellent moderation. And I would also like to thank my colleagues from the Asser Institute who have done an outstanding job in the background. And without them, this annual lecture would not have been possible. So a big thank you to the annual lecture team, Floris, Cecile, Annelies, Claudia, Veronica and Pascal, as well as all our other colleagues and interns that have worked hard to make this lecture a success. Moreover, I would like to thank all of you, our guests, for coming to the Peace Palace in such great numbers and for joining us in the discussion. Thank you for your questions and interaction. And I hope to see you again, of course, at the Asser Institute's training programs, conferences and lectures, including at our next annual lecture in 2025. And finally, please join me in thanking one last time our guest of honor, Professor Fleur Johns.
First of all, congratulations on an incredibly interesting and fascinating lecture and a full house. I think the first question we wanted to ask you was, what do you hope that the audience took away from your lecture today?
Well, I hope they had a sense of possibility associated with the work of international law. I thought the questions were great in that they brought a lot of current conflicts, pressing issues to the floor. And of course, the lecture wasn't meant to answer those or resolve them, but more to suggest the possibility of new relationships, new alliances, new configurations of legal relation around those. So hopefully people got a sense that international law has something left in the tank and it's a sphere of creativity and important work.
Well, there are a numerous amount of takeaways, but the main takeaway that I found was that even though we live currently in a world that is experiencing multiple challenges, multiple events and multiple just challenges to the current, international rules-based world order, I think it's important to gain a foundational basis as myself as a student, as a law student, to understand what the world is going on today.
Maybe it's not full takeaway as in it was all on me. There are so many interdisciplinary things and so many things to connect with and think along together. And there are so many layers. And I think with my question also is that the context really matters. So we shouldn't step aside from it.
Sometimes there comes a time where you have to have a critical evaluation of the way you think about different things in international law. And in this case, more specifically, the notion of community under international law. And so that's why I came to this event as well, because I think it's important to constantly remain critical and reflect on all these different terms that we use.
Today's lecture was just brilliant. I think Fleur Johns is one of the most brilliant scholars, and I think the topic of today, international community, is such a thrilling topic nowadays that I think there was such a great temptation to just come and listen to her.
My main takeaways from today's lecture is how the community and the international community is intertwined, whether we like it or not, and we have to, of course, work together to achieve common goals which are prosperous for the whole international community, not just some actors.
My main takeaway is definitely that the international world is changing and the law is changing with it, and definitely our community is becoming more integrated and less about borders, and there's just more of a sense of humanity, I think.
And why do you think it's important to have these kinds of events for international law and international community in general?
Because the community continues to adopt the language of international law and look to the language of international law to articulate and understand concerns around justice, concerns around equity, concerns around climate change. And so I think maintaining an ongoing dialogue with the public around international legal work, international legal ideas, their limits but also their possibilities is really vital. Because of that interest and that ongoing kind of public vernacular around international law?
I think the event brings together scholars from all over the world interested in things that are at the core of a social question or a political question or a legal question nowadays. So I think it's important to hear different opinions, different views, and engage with them.
It's important to have events like this, especially in today's time, because a lot is going on in the world. It's important to engage with scholars, to have a dialogue with many actors, many players on the international field, to just have a fruitful discussion and come up with potential solutions.
Well, I'm a first-year law student, and I'm still figuring out sort of which route that I would like to focus on, and I thought that coming to this lecture would definitely broaden my understandings and my horizon on the applicability of the law field, and definitely it did.
Well, I think this is important, especially for myself as a law student, to understand, say, the Peace Palace, and to understand just how the world works outside of the theory as well as the books that we all have to read in order to become a practicing lawyer.
I think it's important because obviously, as you can see, there are different types of people, different groups that come in and collaborating, sharing knowledge, sharing their experience, share their questions even. Or for some people, it's also a platform for activism, which was raised today and pretty importantly as well. But also connecting, again, the theme of today, connecting, right? Different parts of the world. Fleur coming from Australia, us living mainly in Europe, for example. So sometimes you need not Eurocentric perspective on things. And important because it's open. Anyone can join basically. So this is that equity and equality basically for people to be part of global topics, let me call it this way.